enforceability of unstamped arbitration agreements. About Mediate Guru. Mediate Guru is a social initiative led by members across the globe. The aim of the organization is to bridge the gap between the general public and litigation. We are creating a social awareness campaign for showcasing mediation as the future. Having successfully conducted various international webinars promoting alternative dispute resolution, having a reach in more than 100 countries around the world, with an international family growing each day, we thrive to provide you the best lectures through the best speakers around the globe so that you have a value addition today. I feel honored today to welcome our esteemed speaker for today's session, Mr. Prashant Kumar. Mr. Prashant is a principal associate with Dua Associates. He is also an advocate on the court in Supreme Court of India and specializes in commercial civil litigation, insolvency laws, and alternative dispute resolution, including uh, Mr. Prashant appears regularly before the Supreme Court of India, High Courts, National Company Law Tribunals, Appellate Tribunals, District Courts, and other fora. Prashant sir also advises clients on various subjects. Mr. Prashant has over 13 years' experience as a legal professional and has dealt with commercial disputes and arbitration matters, both domestic and international, and also insolvency laws. He has handled cases arising from transactions related to oil and gas, infrastructure, construction, power, energy, banking, finance, joint ventures, and general commercial matters. I would request Mr. Prashant to take the session forward and enlighten us all. You can drop your questions in the chat box. Mr. Prashant will take the questions by the end of the session.
Thank you very much. Thank you, Mediate Guru, for your kind introduction and your invite. This topic today regarding the arbitration agreement, stamping of the arbitration agreement, is something which is a really hot topic as of now. And everyone, wherever you talk about arbitration, they will obviously come to this topic to start with. Because the issue of stamping of arbitration agreement has initiated, this topic essentially initiated in 2011 by one judgment. And then in 2023, we have another judgment, which has also created some bottlenecks as far as the arbitration is concerned. Of course, there can be two views with regard to the aspect of stamping, but the issue of stamping, as I said, is really a very troublesome topic, and this topic is something which is really talked about these days. So that is the reason why I thought I will choose this topic. And Mediate Guru is a good platform. I thought, let me just start with this topic and then begin with. So what I have done, I have made some sort of a small presentation, PPT. Garima, if you can just enable the screen share, please.
Sure, sir.
Yes. So this is the PPT visible, Garima?
Yes, sir, it is visible.
Okay. So the topic which we are dealing today is enforceability of unstamped arbitration agreements. And the way in which I will deal with this, there are 3-4 stages in which I would like to touch upon the aspect. First is the importance of arbitration agreement. Then the aspect of stamped versus unstamped agreement. Third will be the aspect of legal framework, recent developments, and some case studies as to what is the implication of the recent Supreme Court judgment. So I'm talking about the recent Supreme Court judgment. If anyone who is who does arbitration matters is aware, there is a recent Supreme Court judgment of Indian Global Mercantile, which is a 5-judgment judgment. So this is the judgment which I'm talking about, and which is the one which is of prime importance as far as this presentation is concerned. But to start with, I'm sure there will be few law students also. To start with, I'll start with the basic arbitration as to what arbitration is. Everyone knows who does arbitration as to what arbitration is. Arbitration is essentially a very simple method of resolving disputes. Disputants agree to submit their dispute to an individual whose judgment they are prepared to trust. Each puts its case to the decision maker, this private individual, in a word, this arbitrator. He or she listens to the parties, considers the facts and arguments, and makes a decision. The decision is final and binding on the parties, and it is the final and binding because the parties have agreed that it should be, rather than because of the coercive power of any state. So this has been defined by Redfern and Hunter on international arbitration. This is how the arbitration is defined. Now, there are various stages in an arbitration. The first stage is the stage of arbitration agreement. Then you have the arbitration commences, and then there is appointment of arbitrators. Once the arbitrator is appointed, you have preliminary meeting for directions, and then the parties complete the pleadings, and then evidence is being led. Issues are framed, cross-examination happens, then the parties submit their written submission, arguments happen, and ultimately an award is being rendered by the arbitrator. And in the end, when the award is there, the award is enforced, or there is a challenge to the award. So these are the stages in the arbitration for any arbitral proceedings to conclude. Now, coming to the topic, which is the most important topic as of now for today, is the arbitration agreement. Now, arbitration agreement has been defined under the Arbitration Conciliation Act. I've just culled out the provisions of the Arbitration Act itself because, according to me, this is a very good definition of the arbitration agreement, which captures the essence of any arbitration agreement as to what the composition should be or what can constitute an arbitration agreement. So it says an arbitration agreement has been defined under Section 7 of the Arbitration Conciliation Act. So arbitration agreement means an agreement by the parties to submit to the arbitration all or certain dispute which have arisen or which may arise between them in respect to of defined legal relationships, whether contractual or not. An arbitration agreement can be in the form of an arbitration clause, or it can be in the form of a separate agreement. So there is that flexibility given to the parties that if the parties want, they can have a separate arbitration clause, or it can be embedded in a separate agreement. Then arbitration agreement shall be in writing. Now, importantly, this is a very important aspect. An arbitration agreement is in writing if it is contained in a document signed by the parties, an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of agreement, an exchange of statement of claim and defense in which the existence of the agreement is alleged by one party and not denied by other party. So if you see the pointers as far as the aspect or clarification with regard to arbitration agreement in writing, the definition is very broad. So if the parties exchange any document which has been signed and which contains an arbitration clause, there is an arbitration agreement. If there are exchanges of letters, communications, or other communications which provide a record of agreement, then also it will constitute an arbitration agreement. Now, in the end, this portion, section 7, subsection 5, talks about the aspect where if a reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement, if the contract is in writing and the reference is such so as to make the arbitration clause part of the contract. So there are certain situations where the parties refer to another third document or second document which contains the arbitration clause. So even if there is a reference which is made to that particular document, then also it will amount to an arbitration agreement.
Sir?
Now, this was as yes, Garima.
Sir, I'm so sorry to interrupt. Actually, the slides are not moving. Like, it's still stuck on the first slide.
Okay. One second. Let me just try it again.
Okay, sir.
Is the second or third slide visible, Rima?
Yes, sir. Now it's visible. Yes, it's perfect now.
Okay. Fair. Now, let us now deal with the aspect of stamping of arbitration agreement. Now, as we all know that stamping and registration are twin requirements for making any document admissible in evidence or for further proceedings. Now, the aspect of stamping is an important aspect as far as the arbitration is concerned. And the basis for that is Section 35 of the Indian Stamp Act. It provides instruments not duly stamped inadmissible in evidence. So the heading of this section says the instruments which are not duly stamped, that means which are not properly stamped or unstamped, is inadmissible in evidence. That means it cannot be admitted as far as any legal proceedings are concerned. So it says no instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence or shall be acted upon, registered or authenticated by any such person or by any public officer unless such instrument is duly stamped. So let me explain what Section 35 says. Section 35 basically says that any instrument which is to be presented in evidence or which has to be used further will not be admitted in evidence by any person. A person can be a court of law, or an authority which has to ultimately rely upon that document, right? So it says that person or authority will not receive the document unless until that document is properly stamped and registered. The proviso to this section, however, makes an exception. It says, I'll come to the provision later, says that in case a document which has to be stamped and it is not stamped, in case that document has to be, how do you make the document valid? So it says that there is a mechanism in which if you pay proper penalty for that, or then if you do some X thing, then document can become admissible. So it says any such instrument shall be admitted in evidence on payment of the duty with which the same is chargeable, or in case of any instrument insufficiently stamped, of the amount required to make up such duty together with a penalty of 5 rupees, or when 10 times the amount of proper duty or deficient portion thereof exceeds 5 rupees. So it's basically sum and substance is this, that you'll have to pay some sort of penalty, and of course the amount of stamp duty which you have to pay. So if you do this, then your document will become admissible. So this is the entire basis on which the further judgments have come into picture, and the further judgments have been rendered, wherein they talk about inadmissibility of arbitration agreement and other aspects. Now moving on to the next slide, the crux of the issue as far as the stamping of arbitration agreement, the issue with regard to this can be summarized as follows. Whether the arbitration agreement or the arbitration clause can be considered as legally enforceable or can be lawfully invoked if the instrument, agreement, or the contract which contains the arbitration clause or the arbitration agreement is not duly stamped as per the Indian Stamp Act. So if you see the interplay between two laws, the interplay between Arbitration Conciliation Act and the interplay between Indian Stamp Act is actually playing out here. So it says that in case there is an arbitration agreement or an arbitration clause which is contained in a document or in an agreement which is not validly stamped, so what will happen to the arbitration clause in such circumstances? So this is the crux, or this is the issue which the courts have over a period of time, starting from 2011, the courts have tried to address this issue. So I hope that the issue as far as the stamping of arbitration agreement, I hope the issue is clear, because understanding of the issue becomes very crucial, because the subsequent judgments will try to deal with this aspect. And ultimately, what is the final conclusion for this issue? I will come to that later, but ultimately, the final conclusion of this issue is something which we have to discuss and we have to ponder upon. So the genesis of this case, this issue can be traced to a case of SMS Tea Estates versus Chandmari Tea Company Private Limited, which is the 2011 Supreme Court judgment. Now, in this case, this is a two-judge bench judgment. So it says when an arbitration clause is contained in an unstamped agreement, the provisions of Indian Stamp Act require the judge hearing the Section 11 application to impound the agreement and ensure that the stamp duty and penalty, if any, are paid thereon before proceeding with Section 11 application. Now, let me first tell you as to what Section 11 application is. So, Section 11 talks about appointment of arbitrators. So, in case there is an arbitration agreement and one of the parties does not appoint an arbitrator, or one of the parties intend to appoint an arbitrator, then an application under Section 11 of the Arbitration Conciliation Act has to be filed before the court. And of course, there are various designated courts for the purpose of Section 11. Like say, for example, for international arbitrations, the forum is the High Court. The forum is the Supreme Court. I stand corrected. For other arbitrations, the forum can be District Court or the High Court, depending upon what the matter is, what the nature of the matter is, right? So the judgment says, the Supreme Court's judgment in SMST says that when an arbitration clause is unstamped or contained in an unstamped agreement, the provision of Indian Stamp Act require the judge hearing the Section 11 application or hearing the application for appointment of arbitrator to impound the agreement and ensure that the stamp duty and penalty, if any, are paid before proceeding with the Section 11 application. So this happened in 2011. This was a very drastic step because prior to this, what used to happen is the parties used to go to the courts. They used to file they used to file the arbitration agreement or the agreement containing the arbitration clause before the court, and they used to make requests for appointment of arbitrator. So this judgment said that nothing doing. If in case the stamp duty is not paid or it is insufficiently paid, then the judge before whom the application for appointment of arbitrator is made, that judge will have to impound the document and the judge will then require the parties to pay the stamp duty along with penalty before proceeding with the Section 11 application. That means these requirements will have to be fulfilled before any arbitrator is appointed. So this was the ratio in the SMST judgment which came in 2011. Supreme Court, what the Supreme Court also says, having regard to Section 35 of the I hope I am audible.
Sir, I have a question. Can I ask it now?
If we can wait till the end, please. We can have your queries and we can deal with the queries later.
Sure, sir, sure.
Right? What the court in SMST states also said that having regard to Section 35 of the Stamp Act, unless the stamp duty and penalty due in respect of instrument is paid, the court cannot act upon the instrument, which means it cannot act upon the arbitration agreement also, which is part of the instrument. So the court very categorically held that that document cannot be relied upon. You have to pay the stamp duty, you have to pay the penalty before the court can proceed with the application for appointment of arbitrator. And of course, there is also a provision under Stamp Act, which is Section 40. So it says, but the court also held in SMST, but if the deficient duty and penalty is paid in the manner set out in Section 35 or Section 40 of the Stamp Act, the document can be acted upon or admitted in evidence. So for starters or for beginners, this can be like, what is the big deal? The stamp duty is not paid, but we have the arbitration agreement, we want the arbitrator to be appointed. But the court in this case, according to me, took a very technical view, and the court said nothing doing. You have to get the things right. Before doing that, we are not going to act on your application for appointment of arbitrator. So, in all wisdom, subsequently, what the legislature did, that post the decision of SMST case, a legislative amendment was made through section 11(6)(a), which came to be inserted in the year 2015, which restricted the scope of judicial intervention to merely examining the existence of an arbitration agreement. So, as I said earlier, the position before was that when a Section 11 application is filed, the court will examine the application on its merit without examining whether the agreement has been properly stamped or not, and the court will ultimately appoint the arbitrator. But because of this SMST judgments, which according to me is a very technical judgment, hyper-technical view, but then the court said nothing doing. You have to first pay the penalty before which we can act upon your application, right? So what the legislature did, they inserted a section 11(6)(a), to overcome the judgment of SMST. And of course, this provision is now omitted from the legislation, from the Arbitration Conciliation Act. But the provision as it read is also mentioned here. The provision reads, the Supreme Court, or as the case may be the High Court, while considering any application under subsection 4 or subsections 5 or 6 of section 11, shall, notwithstanding any judgment, decree, or order of any court, confine to the examination of the existence of an arbitration agreement. So now you see what is happening over here. The insertion of section 11(6)(a) was basically done to overcome the judgment of SMST states. So what the legislature did, the legislature said that whenever an application is filed under section 11, of course, 4, subsection 11(4), 11(5), 11(6), the examination has to be confined with regard to the existence of an arbitration agreement, nothing beyond that. So the examination that whether the agreement is properly stamped or not was kept in abeyance. This happened in 2015. Of course, now this section has been repealed, has been omitted from the act, but this was something which was done by the legislature in its wisdom to overcome the judgment of the Supreme Court in SMST. Now, the next aspect is also very interesting because the Supreme Court itself upheld the judgment of SMST. So the Supreme Court in Garware Walls Roe judgment, which is a 2019 judgment, the Supreme Court held that an unstamped agreement is not enforceable under Section 2H of the Indian Contract Act. The court was of the opinion that an arbitration clause contained in a subcontract would not exist as a matter of law until the subcontract was duly stamped. So the court went a step ahead. So the court held that your stamping argument is fine, but you also see that your agreement is not valid under the Indian Contract Act also. So this was held in Supreme Court in the Garware judgment of 2019. So basically, the Garware Walrop judgment upheld the judgment of SMST, and the court held. In fact, the court also observed something with regard to section 11(6)(a), which is also very interesting. The court says the ruling in SMST case has stayed untouched by the insertion of section 11(6)(a) of the Act. So, what the legislature wanted to do by insertion of section 11(6)(a) has been held to be of no use by the Supreme Court in the Garware Wall judgment. And interestingly, there is another judgment by the Supreme Court. So, Supreme Court in MediateGuru's, which is a 2021 judgment. So now you see what is happening here. 2011, the SMST judgment is passed by the Supreme Court. 2015, there is an amendment by the legislature under the Arbitration Conciliation Act. 2019, there is a judgment of Garware which says that the ruling in SMST's case has remained untouched, even if there is an insertion of section 11(6)(a). And in 2021, the Supreme Court held in MediateGuru's the existence and validity being intertwined with each other, an arbitration agreement would not exist if it is illegal or does not satisfy the mandatory legal requirement for it to be enforceable, one of which is payment of stamp duty. So the development of the jurisprudence as far as the stamp duty on arbitration agreement is concerned can now be seen to be bifurcated, or starting from 2011. We have seen the judgments until 2021, where the Supreme Court has adopted a technical approach as to the stamping of the arbitration agreements. All the judgment says that you have to get the arbitration agreement properly stamped. There are other legal requirements also, but this is a very important legal requirement. And if your agreement which contains the arbitration clause is not properly stamped, your arbitration clause is not valid. Meaning thereby that your Section 11 application, which is an application for appointment of arbitrator, is not valid, is not maintainable. You first get the proper stamp duty on any instrument, and then you come to me. After that only I will look into your application for appointment of arbitrator. So this was the position as far as 2021 is concerned. I am again and again emphasizing on the dates, because knowing these dates and the journey of the this topic is always very important. Now the judgment from which the 5-judge bench judgment of NN Global Mercantile has arisen is the judgment of 3-judge bench of the Supreme Court, Justice Indu Malhotra's judgment. So the 3-judge bench of Supreme Court in NN Global Mercantile Private Limited versus Indo Unique Claim, which is again a 2021 judgment, observes that since an arbitration agreement is an independent contract, it cannot be invalidated merely by insufficiently stamped main contract. So this was a judgment which was out of the league, or if I would put it correctly, if I put it in different words, this was a judgment which took a different position from the earlier judgments until the 2021 Garware judgment. So this judgment says, and of course, according to me, this is the correct position also, but the court says in this judgment that you see the arbitration clause or the arbitration agreement is an independent contract. It cannot be invalidated merely by insufficiently stamped main contract. Now you see there are various legal principles which governs the separability of any clause of a contract. You see the arbitration clause survives even if the main agreement is rendered null and void, or the parties disagree on something and the agreement is terminated. You see, still the arbitration clause survives, right? So, this is the principle of separability. The courts held in this judgment of Indian Global Mercantile that since an arbitration agreement is an independent contract, it cannot be invalidated merely by insufficiently stamped main contract. But there was a problem here. The problem is that this was again a 3-judgment judgment, and the earlier judgments, Garware judgment was also 3-judgment judgment, right? So what the court held that let us refer this matter to a bigger bench, 5-judge bench, constitution bench, who will decide as to what is the correct position. So this is the very 5-judge bench judgment which has been delivered on 25th April 2023, which is the most important judgment as of now on this issue, because this is a constitution bench judgment. Of course, there is a majority view, there is a minority view. I will address both the issues, both the views taken by the Supreme Court. But this is the final conclusive view as of now, right? Unfortunately, what the Supreme Court does in this matter, the Supreme Court in this case held that an arbitration cannot be invoked when the arbitration agreement or clause is contained in an unstamped or insufficiently stamped agreement of the contract. So the Supreme Court also takes the earlier position, which has been taken by SMST, which has been taken by Garware and the other judgment. The Supreme Court toes the same line by a majority judgment. Supreme Court says nothing doing. If your main agreement is not properly stamped, your arbitration cannot rely upon the arbitration clause. So this is the view which has been taken by the Supreme Court as of now. I will now deal with the majority view and also the minority view. The Supreme Court held that this statutory bar contained in Section 35 of the Stamp Act renders the arbitration agreement contained in an instrument or a standalone arbitration agreement on which stamp duty is payable as non-existent pending payment of stamp duty on the substantive contract, public instrument, or the standalone arbitration agreement. So the Supreme Court goes a step further. Supreme Court says that, see, your arguments are fine, right? I know that there is an arbitration clause, there is an arbitration agreement, but till the time you don't pay the proper stamp duty on the main contract, you cannot come to us, or you cannot approach the court with your Section 11 application without payment of the proper stamp duty. Till the time you don't do that, your agreement is a non-existent agreement according to law. So this is what the Supreme Court says. Supreme Court, in fact, goes a step further because see, till now, I have been talking about the main agreement being properly not stamped, right? Supreme Court goes a step further. Supreme Court says arbitration agreement are not specifically mentioned as instruments that must be stamped in Schedule 1 of the Stamp Act. However, under the residuary entry titled, if not otherwise provided for in Article 5C of the Stamp Act, of Schedule 1 of the Stamp Act, stamp duty becomes payable on arbitration agreements. So the Supreme Court now lays down another requirement, or to put it in other words, Supreme Court clarifies the law. Supreme Court says that if the main agreement itself is not properly stamped, you have to get it stamped. Supreme Court also says that there is also residual entry, which the parties will have to follow in case your arbitration agreement per se is not stamped. So you have to get the arbitration agreement also stamped in case you're only relying upon the arbitration agreement. See, as I said earlier, your arbitration clause can be a standalone clause. Your arbitration agreement can be a standalone agreement, or it can be contained in any other document, which can be incorporated by reference or which can be by exchange of communications between the parties. So the Supreme Court, what the Supreme Court does here in a global maritime judgment, Supreme Court says that in case your arbitration agreement or arbitration clause is a standalone document, right? So under the residual entry of the Stamp Act, stamp duty becomes payable in arbitration agreement also. So if someone was thinking, right, on those lines that you see, I just have an arbitration agreement, I just have an arbitration clause that is not contained in any other document or a larger document which on which stamp duty is not paid, I am safe. The Supreme Court says nothing doing. If your arbitration clause or agreement is a standalone document also, you need to get it stamped. Proper stamp duty has to be paid. Supreme Court further says an arbitration agreement thus falls under the definition of instrument as defined by the Stamp Act and are subject to stamp duty. Thus, if a contract contains an arbitration clause or a separate arbitration agreement, it must be properly stamped to be legally binding and enforceable. So this is the majority view of Ellen Global Mercantile as far as the stamping of arbitration agreement is concerned. Of course, the Supreme Court has also dealt with other aspects, but to be concise and to lay down as to what exactly the Supreme Court has said, this is what the Supreme Court says as far as the stamping of arbitration agreement is concerned. Now, I will also touch upon the minority view because according to me, being an arbitration practitioner and being someone who wants that arbitration should be adopted by various parties, being alternate dispute resolution mechanism, I also somehow think that this technical requirement as far as the arbitration agreement is concerned should not have been there. But this is what the Supreme Court says. Now, the minority view is also important here. So, if you see Section 16 of the Arbitration Conciliation Act, which is essentially competence of arbitral tribunal to rule on its own jurisdiction. So, Section 16 is a very important provision under the Arbitration Act. So, the minority view taken in this is this, that according to Section 16(1) of the Act, an arbitral tribunal has the authority to rule on its own jurisdiction, including ruling on any objection with respect to existence or validity of the arbitration agreement. The provision is founded on the doctrines of competence, and separability. So the Supreme Court minority view says that see, when such issue comes before the court or the arbitral tribunal, let the arbitral tribunal decide whether the document is properly stamped, not stamped, and let the arbitral tribunal rule whether it has jurisdiction to act basis that unstamped document or not. So essentially what the Supreme Court wanted to say is that why should the court really bother when the arbitral tribunal has jurisdiction or has powers to rule on its own jurisdiction. So this is first view. Second view, by virtue of doctrine of competence, the tribunal has the authority to decide on all preliminary issues, including the validity of the arbitration agreement or insufficiently unduly stamped instrument. So the Supreme Court says, minority view says that you see, look at the position here. The arbitral tribunal is competent enough to decide whether it has jurisdiction or not, or whether there are some legal impediments as far as the filing of arbitration or initiation of arbitration is concerned or not, right? So if the arbitral tribunal has jurisdiction, why not leave it to the tribunal rather than the courts entering into the realm of taking away that powers from the arbitral tribunal? So this was also one of the views. The third view is the separability doctrine. Now, what is doctrine of separability? As I said earlier also, see, in any agreement, right? If there are suppose there are various clauses. Now, if one of the clauses or one of the documents becomes non-binding, or maybe it is not properly worded, or it becomes legally barred, so the other document or other clauses can be separated from the main document, and that can be relied upon. So the Supreme Court says that in case suppose there is a main parent document which is not properly stamped, or on which proper registration fees has not been done or not been paid, why should the arbitration clause or arbitration agreement suffer because of that? So the Supreme Court says that let the arbitration clause be separated from the main agreement, and let us rely upon the arbitration clause for the purpose of resolving dispute between the parties. So that is in this context, the Supreme Court says that the separability doctrine separates the arbitration clause from the commercial contract. Section 16(1)(a) assumes the existence of an arbitration clause and requires it to be treated independently of the other terms of the contract. Even if the legality of the main contract is contested, the separability doctrine safeguards the arbitration clause. So this was the view taken by the minority in this judgment, which is only 2 judges. The majority is 3 judges, so majority judgment will prevail. But this is an important critique or minority view in my view, because these objections or these observations are the crux of the Arbitration Conciliation Act. See, the arbitration agreement has been drafted, or Arbitration Act has been drafted in such a manner that the arbitral tribunal or the arbitrator has been given a lot of flexibility. Also, a lot of independence has been given. Now, if the court enters into the realm or try to take away the powers of the arbitral tribunal to in whatever way it does, then the aspect of independence of Arbitration Conciliation Act or independence of arbitrator or arbitral tribunal goes away. So this, according to me, is a very good, very well written minority view. But then ultimately the majority prevails. So the position as of now is again, if the contract contains an arbitration clause or a separate arbitration agreement, it must be properly stamped to be legally binding and enforceable. And if the arbitration agreement cannot be invoked when the arbitration agreement or clause is contained in an unstamped or insufficiently stamped agreement or contract. Now, coming to the position as to what has happened after the April judgment in Indian Global Mercantile. So, in my experience and what I have seen is that what the arbitrator, wherever there is an arbitration which has been initiated, or wherever there is an application under Section 11 which is being filed with the courts are insisting that you have to get your agreement stamped. In fact, I have seen situations wherein the arbitration is commencing, arbitration is already commenced, and the parties have led evidence, parties have filed pleadings. There also, the arbitrator now is insisting that you get your, in case there is an insufficiently stamped document, you first get the document stamped properly and then come to me for further steps in the arbitration. So this is the situation which is happening as of now on the grounds. There are in fact 2 judgments also which have tried to clarify or have tried to rationale or deal with this aspect of the stamping aspect. Now, there's a very good judgment of Delhi High Court, which is Splendor Land-Based Limited versus Aparna Ashram, which has been rendered very recently, wherein the court have dealt with the possible issues that may arise after the passing of Indian Global Judgment. So the first issue which the courts have held, the Delhi High Court has held, is whether it is incumbent on the petitioner in a petition under Section 11 of the Act to file the original of the duly stamped arbitration agreement contract, or whether it would suffice for a true copy thereof to be filed. Now, these are the practical issues which the court is dealing with, and I want to appreciate this judgment because the judgment gives out the practical solution as to what will happen or what the parties are entitled to do. Right? See, laying down law is one aspect. but then how or in what manner the law is being implemented is also an important aspect. So this judgment does the job. So the court says a petitioner who files a petition under section 11 of the Act based on an unstamped, insufficiently stamped agreement, arbitration agreement, is required to file the original instrument as executed. However, if the arbitration agreement is duly stamped, the need to file the original instrument is waived if the true copy or certified true copy indicates that it has been duly and properly stamped. So what the court says while dealing with this issue is that see, we want to see the intent of the parties. In case the parties have really executed or paid the stamp duty and have removed the objections or insufficiency of the stamp duty, then in case you're able to file a certified copy also of that agreement, that certified agreement, stamped agreement, that is fine. So this is one issue which has been dealt with by the Delhi High Court. The second issue, which according to me is one of the most important issue as far as this stamp duty is concerned, is this: whether it is permissible for petitioner to pay the deficient stamp duty with the penalty in these proceedings, that means the proceedings before the High Court or the Supreme Court, or it is incumbent to send the concerned agreement contract to the collector for adjudication as to the proper stamp and penalty payable thereon. So what the court essentially is dealing with, the issue is that in case the document is not properly stamped, or in case there is an insufficiently paid main contract, so whether the penalty has to be paid before the court or it has to be sent to the collector of stamps for adjudication as to the proper stamp and penalty payable thereon. I'm not sure how many of you have dealt with this issue, but generally what happens is whenever there is an insufficiently stamped document, the court before which the document is sent can impound that document, and the court then, what the court does is the court will send the document to the collector for calculation as to what is the proper stamp duty, what is the penalty, and the penalty and everything will have to be paid to the collector and not to the court, right? So the court explains that aspect here also. The court held that it is evident from the scheme of Stamp Act, as also noticed in NN Global, that it is open for this court to either send the impounded agreement instrument to the relevant collector of stamps, who will execute the procedure outlined in section 40 of the Stamp Act, requiring the payment of proper stamp duty as well as penalty. Once such duty or penalty has been paid, the collector shall certify by endorsement that proper duty has been imposed. The court may act on the basis of it in the proceedings under section 11 of the Act, of the Arbitration Consideration Act. So basically, what the court is trying to say here is this: that in case there is any document which is insufficiently stamped, that document will have to be sent to the collector of stamps. Now the collector of stamps will then calculate as to what the actual stamp duty is payable and what is the penalty which has to be payable, right? Once and subsequently, once such duty or penalty has been paid, the collector will then certify endorsement on that particular document that proper duty has been imposed, and the court can then subsequently basis the stamping or endorsement by the revenue of collector, right? The court can then act on that document and can allow or disallow the section 11 application, which is an application for appointment of arbitrator. This second procedure, which the court says that the court, it is open for the court to take recourse under section 35 of the Stamp Act and enable deposit of requisite stamp duty along with penalty as contemplated under section 35, and thereafter take further steps as contemplated under or other sections of the Stamp Act. So the court also says, gives liberty to the parties that see, in case you don't want to follow the entire step, you can deposit the amount here and the process can be followed, or the application of section 11 can be considered. So these are the two steps or the two guidelines which the court has laid down as far as the payment of penalty and the stamp duty is concerned. Now, this is the critic, and this critic is a well-researched critic and has been made taking into account the practical difficulties which the parties are now facing. Now, pursuant to section 11 of the Act, the courts have the authority to seize documents in accordance with section 33 of the Stamp Act and send them for review by the appropriate stamp authority, as I explained earlier. Until the documents are stamped, Section 11 proceedings may remain in abeyance. Now, this is a very important aspect because see, in every arbitration there is some sort of urgency, right? You don't want the other parties to do something or dissipate the assets or something of that sort, right? So you want that arbitration, once the arbitration is commenced under Section 21 of the Arbitration Conciliation Act, and if the other party is not in the favor of appointment of arbitrator, you want to proceed further, you want to proceed quickly and get the arbitrator appointed. But because of this requirement of this global judgment, now in case it's the parties, bad luck, or if I would call it like that, if the parties, there's a bad luck with regard to the parties and the document is not stamped, then the document will have to be impounded. Proper stamp duty will have to be paid. And dealing with collector revenue stamps, all these stages or all these steps takes a lot of time. So the crucial time, right, is lost because of this. So this is one critique. The second critique is more in the context of institutional arbitrations. Now, there are two types of arbitration. One is ad hoc arbitration, which is by appointment of arbitrator ad hoc, and the other one is institutional arbitration, where there is an institute which takes care of the arbitration proceedings, right? So, in case of an institutional arbitration, where the challenge is before the appointing authority, the authority has no power to impound the instrument or send it to the concerned authorities for adjudication. This is because the appointing authority is neither a receiving authority nor the authority in charge of a public office, as defined in Section 33 of the Stamp Act. Furthermore, the institution rules do not allow the appointing authority to stay the proceedings until the stamping defect is rectified. So you see the practical difficulties, what is happening here. The adjudicating authority or the authority of where the arbitration is supposed to happen, that doesn't have power to impound document, right? That doesn't have power to stay the proceedings. Once a request is made for appointment of arbitrator, they have to act, right? Thus, creating an imbalance in the remedies available to those who seek arbitration through the courts under Section 11 of the Act and those who seek arbitrations through institutions. So you see what is happening here. There is some sort of imbalance which is being created, or imbalance has been created because of this judgment, right? Because the institutional arbitrations does not have equal powers like a court. So who will impound, whether the document has to be sent to the collector or not, whether they have powers to stay the proceedings or not. So these are very crucial issues for which there is no clarity, and the parties will have to act on, on their whatever good wisdom they have, right? So this is a small critique as far as this global judgment is concerned. Now, interestingly, just 2-3 days back, there was this judgment from Karnataka High Court. Now, as I said earlier, there are various stages in arbitration. I'll just go back to the slide, the first two slides, so that we can understand it better. Now you see the last two stages. When there is an award, you go for enforcement of the award, or execution, enforcement or execution of the award, right? Now coming back to the judgment, which is an interesting judgment of Karnataka High Court. So the court held that penalties for insufficient stamping cannot be imposed on arbitral awards during the enforcement or execution stage. So the court says that nothing doing if we are seized of a matter which only pertains to execution of the arbitral award, then we are not concerned whether there is an insufficiently stamp or not, stamp duty payable or not. The court noted that Section 33 and 34 of the Stamp Act, which mandates and requires an insufficient stamp instrument to be impounded and consequently penalty to be imposed, cannot be extended and applied to arbitral awards. So now you see what is happening. There is a Supreme Court judgment, 3 judgments, 3-2 judgment in global mercantile, which says that you see, in case you have an arbitration clause or arbitration agreement, which is contained in a document which is insufficient stamp, that document cannot be relied upon. And now you have this judgment from Karnataka High Court, which says that see, as far as the court says that you may be correct as far as the initiation of arbitration, but the arbitration has not traveled the entire journey. We are at the stage of execution of arbitral award. So at this stage, we are really not bothered whether there is any insufficiently stamped, whether the document is insufficiently stamped or not, because we are at the very final stage of execution of the arbitral award, right? So, basis this, the court does not essentially gives a lot of weightage to the Supreme Court judgment, and the court says that we will not be guided by the Supreme Court judgment as far as this aspect is concerned, as far as the execution of arbitral award is concerned. So now the position net as of now, until there is another judgment, there is another constitution bench judgment which will say that what is the effect. We have to live with this judgment. We have to comply with the requirements which has been laid down by the Supreme Court. We have to pay the proper stamp duty in case it has not been paid. Even if there is a standalone arbitration clause or standalone arbitration agreement, you will have to pay the proper stamp duty if not paid. Even if there is an arbitration clause or arbitration agreement which is contained in the main document, which is not properly stamped, there also you will have to comply with the requirements of law. You will have to either get the document impounded and the penalty computed, and you will have to fulfill the requirements of law. So net, the position we are as of now, as I said earlier, has been laid down by the Inner Global Mercantile Judgment, and that is the final law as far as the stamping of arbitration clause or stamping of arbitration agreement is concerned. I think with these words, I have more or less covered the aspects of stamping of arbitration agreement. I will be happy to take questions, and I hope I was clear as far as the presentation is concerned. Very good. Over to you.
Yes, so it was indeed a very informative lecture. Now we'll engage in a question and answer session with our esteemed speaker. We have some questions from Dr. Kishore. The first one being, is this a welcome judicial intervention by Indian courts in arbitration proceedings?
See, what the court has done, according to me, the court has taken a technical approach, right? Of course, there are various views, there are contrary views on this. Someone says that no, what the court has done is correct. Someone says what the court has done is not correct, because this is not a pro arbitration judgment. A pro arbitration judgment was the judgment of three-judge bench by Justice Indu Malhotra, which said that you can segregate the arbitration clause from the main parent contract, and that document can be acted upon. So this is definitely, according to me, this is not a pro arbitration judgment, but of course, this lays down the correct law, the correct position of law.
Okay, thank you, sir. Does such judicial approach create confusion and scare away foreign parties from India?
Yes, to a certain extent, yes, because see, when anyone adopts the arbitration law of India, or anyone says that India will be the seat of arbitration, they don't want to be faced with these issues of stamping of arbitration clause or stamping of arbitration agreement. Plus, the law is also not very clear, right? Every state has their own stamp act, stamp law. Every state the law differs. The stamping requirement differs. The registration requirement differs, right? So why should the foreign parties be really bothered as to what stamp duty I'm supposed to pay, right? So according to me, yes, this is a deterrent, but if explained properly to the foreign investors, foreign parties, that see, this is the requirement of law, we have to comply. Everyone complies that. So I think if that is done properly, then in that case, then it may not be a deterrent.
Do analogous provisions exist in foreign jurisdictions that are preferred or favorite arbitration seats and venues?
See, if I understand the issue or the query correctly, do analogous provisions exist in foreign jurisdictions that are preferred? See, as far as the favorite seat arbitration seat is concerned or venue is concerned, according to me, there is no favorite as such. See, it totally depends on the interest of the parties, totally depends on the, what the requirements of the clauses say, or what the requirement of the arbitration clause says. If suppose there is a requirement and both the parties have agreed that Singapore will be the seat of arbitration, or let's say, for example, London will be the seat of arbitration, right? So that is one view. See, the second view is with regard to analogous provision. If I understand the query correctly, I have not seen in my experience that there are analogous provisions in other jurisdictions which says that you have to pay the stamp duty. I may be wrong because I'm not examining the law who are all the countries, but whichever country I have read with, they do not have any such requirement of stamping of arbitration clause per se.
Oh, we have next question. How much does it cost to get the arbitration clause or agreement to get it stamped?
See, as I said, stamp duty is a state subject. Every state comes out with their own rules, right? The requirement at some places are very nominal, 100 rupees, 200 rupees. The requirement at some other places may be more because if you see the Schedule 5C in Unstamp Act, the residual provision. So in those cases, generally it's very nominal fees. But yes, having said that, I will also qualify this by saying that the requirement varies from different states. But if there is only a simple agreement, simpliciter, then in like Haryana or in Delhi, the requirement or the payment is very nominal, 100 rupees, 200 rupees, that's it.
Okay, sir. Um, why do parties fail in fulfilling such basic requirements?
See, why does a requirement come? A requirement basically comes from, if there is a law which prescribes that you should do it. Of course, today also there are laws which say that you have to get the agreement properly stamped or properly registered, right? If I advise someone, I say that whatever it takes, you have to get it registered. So maybe a lot of times if they are ill-advised, a lot of times they don't know that this is the requirement of law. I think these are the only two ways in which the parties essentially miss out of these essential requirements.
Is Karnataka High Court judgment in Shakil Pasha case against the constitution as far as finality by Supreme Court is concerned?
So I would say this is not a there can be I mean of course this judgment has not been challenged as of now because this judgment just came 2 3 days before, right? So this is not against the constitution, but there can be there can be a challenge subsequently later which will and the challenge can be dealt with by the Supreme Court. So ultimately this judgment essentially says that see as of now if there is no requirement for execution, the requirement of stamping of an arbitration agreement or a clause or a document is when it comes to section 11, which is the appointment of arbitrator, right? So a distinction can be drawn. But tomorrow, you never know there's a challenge before the Supreme Court. And the Supreme Court says that see, I have given this requirement. This has to be at all the stages. See, until unless there is such a requirement by the Supreme Court, I don't think this judgment is wrong. These are the answers. Anyone else? Anyone not audible?
Okay, I'm so sorry. I think that was the last question for today. Participants, if you have any more questions, you can drop it in the chat box. So, we don't have any more questions. Yes, we do have one. What are the new challenges before the arbitral tribunals in India now?
Oh, there can be an entire session. There can be an entire session for this. But then a lot of challenges are there. See, this is of course today, as of now, if I tell you today, this is one of the very big challenge which all the arbitral tribunals are facing, right? There can be other challenges also. There can be like, there can be a case where there is not a proper representation by the parties. There can be a case wherein the arbitration is just initiated for some sort of, for arriving at some sort of settlement. So there are various challenges. I can take an entire session as to what the challenges are there before the arbitral tribunal. But I think these are the some of the challenges which the arbitral tribunal faced.
Thank you, sir. That was the last question for today. Thank you, Mr. Prashant Kumar, for an engaging and enlightening session. I'd like to express our gratitude to all the participants for joining us today. Um, yes, the recording will be available on our YouTube. So you can if you miss this session, you can go on YouTube and you can definitely see this lecture on lecture there. Before we conclude, I'd like to announce that Mediate Guru is announcing its third international arbitration moot in collaboration with Denton's Link Legal and Gujarat Maritime Cluster. We do have a few slots available, and you can register by tomorrow. Don't miss this golden opportunity to compete with the global teams and gain practical insights in the field of arbitration. Thank you again, everyone. So, would you like to say anything before we end the session?
No, I think this was a very engaging session today. And see, when I speak in any topic for any topic, it's also a learning for me, right? Because you get the right questions which you need to answer, and most importantly, right? I mean, these are very live issues which every arbitrator, which everyone who is dealing with arbitration these days is facing, right? So thank you, Mediate Guru, for this invite. And thank you for a patient hearing, I would say, a patient listening to my session. It was a really nice session.
Thank you very much, sir. Thank you, participants, for your time. We'll end the session now.
Thank you, everyone.